private legal practitioner, joining us. Good morning to you, and nice to have you on the line once again.
Good morning.
I hope you're well. I hope you're well.
I was great, fine.
Well, first let's start from this matter, because we're just discussing this matter of the petition that was seeking to stop the processes or the hearing, the work of the committee that was hearing the petitions asking for the removal of the CJ. The particular petition was about one of the justices, two exactly, with another justice being seen in the company of a lawyer of one of the petitioners in a restaurant. Well, we found out that might not exactly be the case. But what do you make of that being a ground to ask for the committee's hearing to be stopped?
Well, I guess that incident is being used to raise the real likelihood of bias in the committee or in the members of the committee that probably were affected with the other council. But, you know, the real likelihood of bias as a standard is set within our jurisdiction clearly in previous matters, you know. So what I can say shortly, if you go through the cases on real likelihood of bias, that's what I see as the footage of what is being complained about does not constitute real likelihood of bias in the judges or in the members of the committee that were cited. That's number one. Number two, I'm assuming that even a meeting of that sort probably had happened. But as you rightly said, from the footages, we knew what we saw was actually not a meeting. It looks like a fortuitous, it's a coincidental incident that they both met at a place of eating and had to exchange pleasantries. That's all we see now, but of course that cannot constitute the grounds for the request that the petitioners are making. Number two, you can see that that incident involved just one of the lawyers for one of the petitioners. But we have more than one petition that's being investigated by the committee. And that is, so which means that the rest of the two, even if we are to assume that that meeting has tainted the process with respect with one of the petitions with some form of unfairness, the rest of the two are still pending, and those lawyers were not seen in that footage. And therefore, it cannot be used to hold off the proceedings with regards to the rest. And thirdly, you will see that, you know, these issues for me actually are needless. I don't know the circumstances under which those three judges met, and you would see that it wasn't just a conversation, it wasn't just an interaction between a counsel and one of the members of the committee. There was another judge who was not a member of that committee, who was in the company of that other judge. So which makes it looks more coincidental than planned. And number four, we see that there was no meeting. And even if there was meeting, we don't know the content of the discussion. So, of course, if a matter is pending before a judge, as a matter of principle and as a matter of judicial conduct, that judge is not supposed to meet one of the parties or counsel for one of the parties in secret or in private. Even if the discussion relates to something completely different. Because justice delivery is about also perception. And as we all know from the common law, they say not only must justice be done, but it has to be manifestly seen to be done. And so perception is very important. The optics are very important. And that's why we say a matter pending before a judge should be a ground for the judge not to meet any of the parties for any other purpose until the case is over. But of course, this is not one of such meetings, as you rightly pointed out, because I have seen the footage that's in circulation, and I believe many people have seen. It is not that kind of meeting that it's not that kind of meeting that is contemplated within the rules governing the likelihood of bias. But let me also say that I have always made the distinction between the likelihood of bias that we set for ourselves in our judicial decisions and the one at common law. And I might say that even the one we have set for ourselves has gone a step below the common law standard. Yes, because the common law standard is that you should not do anything that looks like that is in the semblance of interference with the judicial process. But in our case, so in the common law jurisdiction, bias or a perception of bias is sufficient. But in our case, perception of bias or even bias is not what we have chosen for ourselves. In fact, the judges add something we call real likelihood. They added real likelihood to the bias, which takes the standard a step below the common law standard. And so for me, I think we are making a storm in a teacup. This is not the kind of situation that calls for a terminating of the proceedings. But as it stands, the point is the matter is before the court, and I think the court has exclusive jurisdiction to deal with it. Then the second, I think the second thing they're asking for is the seizure of the presiding judge. They also ask the presiding judge to stop presiding. So I know you haven't asked about that question, but it's one of the things they asked for. And I think it's also important we discuss it. Yep.
Well, on that matter, because and what is your comment on that a presiding judge should not preside over the matter any further?
Now, the decision, the reason they base that on, reading from the application, is that the judge has determined a matter in relation with these petitions, or he was a member of a panel that determined a matter that is related to the petitions which inquiry they are now doing. But that sounds a bit preposterous in my mind, because look, if the judge, let's assume that he was even a member of the panel that decided a matter in relation to that. The question we should be asking ourselves is, how is the relations between the issue that was determined by that panel and the inquiry that they are making? Because all boils down to administrative, judicial fairness, and also real likelihood of bias, as we put it. So, if the matters are not mostly related, or if it is just one issue which is not being inquired into by the committee right now, then of course there is no issue here. But secondly, and most importantly, the involvement of a judge in a decision in the Supreme Court. And let me emphasize, I'm limiting this to the Supreme Court because this is a constitutional restraint. Now, in the Supreme Court, the members or the judges of the Supreme Court are allowed by the Constitution to deal with matters in a different stage which they have involved themselves in the laws, except that the matter had been dealt with in the lower court. Why am I saying this? You will notice that in the Constitution, there is an opportunity for a party to apply for review of a decision, right? If you take a matter to the ordinary panel of the Supreme Court, an ordinary panel here means the first instance that the case goes before the Supreme Court. It can be a panel of 5, 7, 9, or any number beyond 5 who will sit on the matter. Now, if you are taking the same matter for review, the rules we have been, the rules and the practice do not exclude the previous judges who determined the matter at first instance. I'm talking about review here. And you will know that the review of a case is exactly a determination of the same matters that were related in the first instance. But usually when there is a review, they just add 1 or 2 judges to the previous panel. And the panel will continue with the determination. So every member of the panel that previously was part of the determination of the matter at first instance is also made a member of the panel for a determination of the review. So is that to say that there is real likelihood of bias? Because, I mean, you are alleging that some error has been made by the earlier panel that resulted in miscarriage of justice. And that same panel is part of the decision. The Constitution does not construe that, does not see that as an incident or an instance of real likelihood of bias. So it is allowed. Our practice allows it. So if we extend this to the committee, now the committee is making an inquiry and to make a report. Now let's also be mindful that the committee's final decision is not a judgment of court. Yes, it is not like a judgment of court. It is a recommendation. And that member, the presiding member, is not the one to determine what should be recommended. The whole panel will be part in determining what should be recommended to the president.
Okay.
You see, and so for me, the involvement of any panel member in the determination of an earlier suit in relating, that is assuming that it even relates, because I have dealt with the circumstance where it doesn't relate, because we don't actually know, I don't actually know the matters that were alleged to have been decided by the judge, and they are relating with the issues that are being inquired into now. but you would see that the processes are different. Adjudication is different from inquiry. You see, here they are inquiring into matters of facts. They are establishing evidence. They are seeking to establish the facts with evidence and to make a recommendation as to what to happen. And so here they are acting like a fact-finding mission. And so I don't see how that function will be influenced by any earlier determination of the matter in relation thereto. And so for me, this is it. But you see, I always think that, you see, when we choose a principle today, that principle must apply across board. But because principles, facts may change, but principles do not change. Principles are immutable. They may just be applicable to certain facts and not to certain facts. And so when we choose principles for ourselves, it is always my anticipation that those principles should be applied in all similar circumstances.
Okay. Laura, I know this will, because this will take some time, and I have a scheduled interview. What we'll do is that let's book a date for Monday, so that, because there are many questions, because even with the two justices that the Chief Justice's suit is asking to be off the panel, because the Chief Justice's suit is attacking everybody in the committee.
Yes, even the suit itself and the form is something that needs to be.
Yes. So we'll spend some time Monday and go through each of what they are requesting for, and if there are any problems you see with them. But thank you very much. Thank you very much for speaking to us this morning.
Yeah.
That's